Hi, everybody. I hope you're having a good evening. Wow, it sounds like I've lost my voice since I've been back or since I've been gone. But I hope everyone's having a good night. If my voice keeps sounding this terrible, then I might come off of here. Maybe I am just need to drink some water though, so we'll see. But I hope everyone is having a good night tonight. Earlier I was on here going over my tort flashcards, and that's what I'm going to keep doing. I'm going to try to make it through this deck of flashcards. We'll see. Um, but I left off on landowner duty. I somehow lost my voice since last time I was alive and now. So we'll see how this talking goes. If I keep sounding this bad, I might hop off. Um, okay, but let's get started. The first thing we want to go over is negligence per se. Torts. And per se means like by and of itself, so by itself. Um, so negligence first, whenever you see per se in law, that means almost like automatically. So what this means is if you do one of these things, you don't have to prove you're negligent. Just doing it means you're negligent. So, for example, like if you left a door unlocked, you would have to prove that like leaving the door unlocked was negligent. But if it fell under negligence per se, if you left the door unlocked, it's already decided you're negligent. But leaving the door unlocked is not a negligence per se act. There are so negligence per se occurs when there's a law and you break it. And just by breaking the law means you're negligent. So the elements of negligence per se, there has to be a statute. A statute is a law. Um, you have to violate the statute. Um, the person harmed has to be the type of person the law is meant to protect. And the harm caused must be the type of harm the law is meant to prevent. Okay, let me check that that was right. That was just from my memory. Okay, perfect. All right. In negligence, what standard of care applies to a professional? Um, and what that means is, um, well, I think so. Professionals, meaning like lawyers, doctors, they have to give the amount of care that like if I remember right, their like ethics rules say. So like lawyers have rules of ethics, um, or well, not just of ethics, sorry, but lawyers have rules of how things are done, doctors have rules of how things are done, and if you violate them, then automatically that is negligence. Let me double check. Um, okay, that kind of wasn't exactly right. So you can admit evidence of the rules, but the magic phrase you have to have is same skill. Yeah, I was way off. Care as an ordinary practitioner in the same community. Okay. And then the evidence can be like rules or standards of care. So, for example, if the rules say the doctor should do this, and you can show in court the doctor did not do that, then that is evidence of negligence for professionals. Okay. Sorry, excuse my voice. Okay. Next is, oh, this one will be fun to explain. Res ipsa loquitur. This is one of the fun ones. It's fun to say. So res ipsa loquitur. Do I remember what exactly the Latin translation is? No, but I think it means like, I think, I don't know, I'll look it up after. But res ipsa loquitur means that the only way something would have happened is someone was negligent. So, like, for example, let's say you're like walking you're walking past a building and a piano falls out of the window and hits you. That's not supposed to happen. That's never supposed to happen. Pianos are not supposed to be falling out of windows. So you could go to court and say, this is a case of res ipsa loquitur. The only way this piano would have came out of this window is if somebody made a mistake, somebody was negligent. Yes. Now let's look at how they explain it, because they are going to this flashcard's going to explain it better. Yes, it is. Okay. So you need to prove the accident doesn't happen without negligence. The damage was caused by something in control of the defendant. So, meaning you need to sue the person who had control of the piano at that time. If like a piano fell out of the building. And the plaintiff, not. Okay. Let me look up. I'm gonna look up a couple more, maybe two more examples of res ipsa loquitur, because I feel like that'll be good for me and maybe you. But oh, okay. So if you get surgery, excuse me, I meant to mute myself. If you get surgery and someone leaves like a sponge in you, or like some type of surgical instrument, that's never supposed to happen, right? That's because someone made a mistake. They shouldn't be leaving anything behind in you. Yes, so that's an example for res ipsa loquitur. Or if someone drops a hammer at a construction site, that's also never supposed to happen. The only reason it happened is because someone was negligent. Okay. But I need to remember that technically you need to prove three things. In law school and legal writing, they love like lists and very orderly, organized things. So that's why you see me labeling things, because I can explain it, like it helps to explain it out loud, for me, but then when I write it down in the exam, I need to be able to use like the actual language. So anyway, the three things to prove for res ipsa are the accident wouldn't have happened. The accident really only happens when there's negligence. Um, the thing that caused the accident must be in the exclusive control of the defendant. And I already forget the third thing. I'm not going to forget the third thing. The third thing, I'm looking up at the ceiling right now, so I don't know exactly. The third thing, it has to be in control. And it was not any fault of the plaintiffs. Nice. Okay. Hi, CH. I know. I don't know what happened. It probably going, maybe I'm going live too much studying, but it's actually kind of fun to study. I'm very happy you're here. I probably won't stay on very longer because I probably need some rest. Res ipsa loquitur, so the hot these coffee do not fall under this because people know coffee is hot. Yes, but that's actually such a good example, and that case comes up a lot in law school. That actually, I shouldn't say this, but the issue with their coffee was extremely too hot, but they did it on purpose. So they weren't even negligent. I think it was like, I have to look it up. It's like 400 degrees. Like the woman who the coffee dropped on, she had a horrible burns all over her. And like it sounds like a silly lawsuit, but like she actually really, really was hurt, and it was like not safe what they were doing. Um, what was the temperature of the coffee? It was crazy. But you're exactly right. You normally people would know that it would be hot. So I actually think you probably could make a good argument, CH, for sure, because people spill coffee all the time. It wasn't like the spilling the coffee that made the accident happen. It was how hot it was. Yeah, that's a really good example. How hot was that coffee? We saw pictures of the burns in class, and I was like, oh my God, I don't want to see that. 190 degrees Fahrenheit. I can't really like think about how hot that is, but that's pretty hot. That must be. Okay, it's hot enough that it caused third-degree burns in 2 to 7 seconds. Wow. Yeah, I feel like there's some cases that are, well, I mean, that's a very famous case, so that's probably why we talk about it so much in school. Okay, what is my next flashcard? Huh? I don't know what this means. What is the effect of a plaintiff's estat? Oh, so once you have established res ipsa, so that means you've once you've convinced the court res ipsa exists, what happens next? You probably prove your damages. Oh, boiling point is 212. Oh, that's close. That's pretty hot. But that's not as hot as I thought it was. I thought it was much hotter than that. I don't think I've ever, I was thinking, CH, I was thinking in my head, I was like, have I ever touched boiling water? And I really don't know, but I imagine it must be like pretty hot, obviously. Um, okay, so if you prove that it's res ipsa, you're proving, I think, oh, you have to prove causation? Oh, no. Um, Hi, Maury. I was just telling CH, I like left for dinner and came back and my voice is so scratchy. So I'll probably be on for a little bit longer. Like my throat doesn't hurt, but I just sound I don't know. I did watch a World Cup match, but I wasn't yelling. Um, because my roommates and I went out to dinner. Okay. So res ipsa loquitur, when that happens. Okay. All this does is um what am I trying to say? Protects against dismissal. So if you're bringing a negligence case against somebody and you can convince the court that whatever happened, the only way it happened was because someone was negligent, then um, you'll survive any attempt they make to dismiss your claim. But that's about it. It doesn't mean you won the case. This just means you've created what we call prima, I can never say it, prima facie case. If you watch law tubers, they say it all the time, and I swear everybody says it differently. It creates a prima facie case, and that means on its face. So that's like at first glance. So anyway, if you want to try to protect your negligence lawsuit from dismissal, you want to try to prove res ipsa. To prove res ipsa, you have to prove that the thing would only happen if someone was negligent and that the defendant had control over the thing, and that it wasn't the plaintiff's fault. Okay, cool beans. All right. My least favorite, oh my gosh, I hate this topic in torts, is causation. Proving, and then I hate this in court, I hate this in torts and like crim. And I kind of like think of torts as like criminal law and civil. Like that's not exactly right, but like they say don't think of it this way, but there's kind of like for a lot of torts, there's an equal like crime too. Um, so anyway, just like you have to prove that someone caused something with the crime, that like um like the person did the crime. And torts and negligence, you have to show that the person's actions caused the harm that you're suing for. And that can get really hard when there's like a lot of people who might be responsible, um, or you might be partially responsible. But anyway, okay. So this flashcard's asking me, what is the causation test for actual cause? All right, I should just write this down. So there's two types of causation. There's actual, which is called the legal cause, and the proximate cause. I'm going to take this out because I actually don't know. I think proximate might be the legal cause, and I think this might be the factual cause. We'll see. Anyway, the first type is that to prove that, well, I should answer the flashcard. This is like my ADHD kicking in, so sorry that I keep stopping and starting. Flashcards asking me what test is for actual cause. That is is that the but for test? Was it? Okay, I just gotta look. Yes, okay. Um, yes, this is the but for test, which is such an odd phrase. But it just means without. So you prove that but for without the action there would be the harm would never happen. Okay. Yes, and I was right. I'm glad I switched that. Good. Actual and factual go together. Yes. Um, ECH, would that be like the McDonald's coffee could be the manufacturer of the coffee maker held some responsibility? Yes. Yes, that's exactly right. Exactly. And that's actually such a good example because that's why there's two examples. There's two types of causation you have to prove because um let's say the machine um like if the let's say the workers were like making the coffee hotter than the coffee machine's instructions said. um so like using the coffee machine is a cause for like the hot coffee, but it's not like the most direct cause. The real cause was like the McDonald's worker making it 190 degrees. Um, but um, like someone would probably sue the coffee maker just to try to get them in there. But yeah, that's exactly what those types of cases. And that's where you would get multiple people maybe responsible. Maybe the coffee machine shouldn't have been able to go up that high and a worker shouldn't have tried it. Um, yeah, that was the McDonald's coffee was a really good example, CH. I completely forgot about that case. Yes, actually the most probable cause of the harm. Yeah, exactly. Um, Without it, then there wouldn't have been the harm. And so that's one half of causation. I'm guessing my next flashcard will ask about the next type. No, but it'll come up. What test is applied by courts when there's two or more people who have contributed to an indivisible injury? Okay. If you have multiple defendants, they are, well, there's a lot of tests. Um, what test is applied for the conduct of two or more? I don't know. I think when there's two or more, I don't know. I'll keep starting and stopping sentences. I should just look. Okay, yeah, I wasn't gonna say that. The substantial factor test, which I always think is a very silly test. Which just literally means um, the court has to decide if the action was a substantial factor in causing the harm. So, what are some examples of this? Like if, well, the one I can think of right now is like, um, if a bunch of companies were sued for like pollution, um, it's hard. It might it might be hard to like quantify exactly like, you know, how much of the like physical like the health issues that people got from pollution, like how much of that is owed to exactly one factory if there's like eight factories going at the same time. um yeah, I think that's probably a good example. Oh, CH, I'm so glad you're here. Um, Looking at proximate cause can use circumstantial evidence that the accident didn't just happen without someone being careless. A bridge could collapse because the wrong cement or screws were used. I see, I see, I see. That's exactly right. And I feel like I definitely remember. Yeah. Um, yes, that is exactly right. Because, um, for example, in the coffee machine example, um, you could you could say, well, if they didn't use the coffee machine, there wouldn't have been coffee and then it wouldn't have burnt me. But the second type of causation would have limited it because um, you can make coffee with that coffee machine all the time. Something else must have happened. And I think that's exactly what you're saying, CH. Um, the person who probably like set it to be that hot is the one responsible. Um, Nice. I love this. I also this is actually great because everyone really likes study groups, but I really don't like study groups in law school. But this I like. And I'm glad that you're finding it interesting. It's kind of just like a puzzle. And yeah, you just have to kind of fit all the pieces together. It's just the hardest part is memorizing all the freaking pieces. Okay. What is joint and several liability? All right. So, joint and several liability. Which I'm kind of confused why they have us learn this because it's eliminated, um, because it's eliminated in most places. But if there's multiple people responsible, then the plaintiff can collect all of the judgment money from one person, or they can split it apart. So they can hold everyone jointly together responsible, or they can hold you separately or several by yourself responsible for the whole amount. But now that's considered unfair, and most states don't do that, if I am right. Okay, let's see. Well, it has to be single and indivisible. Okay, yes. The plaintiff has the choice of collecting the entire, oh, that's almost exactly what I said, the entire judgment from one defendant or portions from various defendants. Um, All right, and I was very wrong. You should always use this. Okay, so this is there's a note on my flashcard that says that on the bar exam, always use joint and several liability unless they tell you otherwise. And I was not going to do that, so I'm glad that they said that. CH. Or you, excuse me, or you get mold in your house because the contractor didn't put the right waterproofing on the foundation. Yeah, exactly. But you wouldn't, and that's exactly right. Um, because even though like the person who built the house, if there was no house, there'd be no mold. But that's not really a fair argument. It was actually like the contractor's fault. And that's where the contractor would fall into that second type of cause. Um, yeah, those are really good examples. I feel like mold is an example we use a lot. Termites, that's another example that we use a lot. Um, I had to write a memo once on someone sold them a haunted house, and like we had to feel like I don't know, it was very weird figuring out like the like legal ethics of that. Maury, I'm thinking of that condo complex in Florida oh my gosh, that collapsed a few years ago. Construction defects, the builder cut corners on rebar. Oh my gosh, Maury, that is my nightmare. I was, I don't want to say like fascinated, but just like really, really horrified by that because like the people were just sleeping and like it just fell like a pancake. And yeah, oh my goodness, reading like all the corners that were cut and like the alarm bells that were sounded. Oh, I was Maury, I forgot about that. That's so bad. Yeah, so bad. CH, remember tries delayed. And see, it's funny being on the other side, CH, because I always get like, especially in Jolene's chat, I mean, it's just like double ADHD, and I'm just like, she's not seeing chats fast enough. And I always forget that chat is delayed. It was so awful, Marie. Oh, yeah, that was so awful. Gosh, in law school, I swear it's been like my risk appetite or like my risk tolerance has gone down so much. Like I won't ever go skydiving. I'm not gonna ever go bungee jumping. Like I'm not going, I don't want to do any of those things. And especially after like sitting through school classes and hearing all the things that can go wrong that you don't think of. Um, oh, like one case that still sticks with me is someone stood on top of their washing machine and their washing machine was glass. And I mean, obviously that's like very like don't do that. Not good. But they did do it and it was of course worst case scenario and they like just fell through and it just like really messed them up. For some reason like that sticks in my mind because it's just like I could totally see myself being like I can like hop on this for a second and like grab something and like now like my like awareness of risk would never let me do that. Or the Grenfell fire outside of London a few years back when they used the wrong cladding on the building to save money, which became fuel to the fire. Oh, I feel like I heard of that too. And it's just so awful hearing things like that because it's so, I mean, it's so preventable. It's kind of like the washing machine thing. Like, in a way, I mean, maybe they probably knew. They probably didn't know that. They knew there was a chance that those things could happen, but they probably thought like the risk was worth it and it wasn't. And I feel like that's exactly what law school has made me do. Like I'm always thinking like it probably won't happen, but if it does, like how bad is it? And that's actually how like um in some places they judge negligence. So even if there's like a small chance that something bad could happen, if the thing that could happen is like catastrophic, like you better protect against it. And that's exactly where these people didn't. And it would have just cost a little bit more. It's very sad. Gren Grenfell, 70 people died. Wow. Let me look that up. I don't know if I know that. Oh wow. Gosh, that's so sad that it's just because of that. Crazy. Oh, Chris's life insurance company canceled her policy before she went on the shuttle. Oh, of course they did. That's crazy. Wow. Wow, that's really crazy. Actuaries know things, I guess. Yeah, that would have been a, probably a huge payout. Wow. I mean, it is really risky thing to do. I don't think I would, I don't think I'm, I think I'm, I don't think I would be doing a space shuttle either. I don't know if I would do a helicopter. I've done a hot air balloon, and that was actually very peaceful and fun, but that was before law school. I've definitely read a hot air balloon case, so I'm not sure I would do one. But it's very, very nice. I recommend a hot air balloon. Oh, Maury, you don't like helicopters either? Yeah, they scare me. And right now, where I live, it's like I'm surrounded by a bunch of hospitals and it's constant helicopters, and it sounds like they're going. It literally sounds like they're going to like crash into my house. They're so low and so loud. No, and I do not like the idea of like, people who are just casual pilots and they'll be like, oh, like, let me take you out for a flight or something like that. Mm-mm. I don't want to get into a plane with any like casual um, pilots and small planes. Mm-mm. So, because I've had like friends who are like, oh, I'm getting flying lessons. I could take you on a flight. And I'm just like, no, I'm okay. CH, would being in a space shuttle be considered a risky behavior that insurance company would litigate for a long time? Yeah, there could be a lot. Yeah, there could be a lot of reasons. Just like insurance companies will like, I don't know. It's possible that there may be a clause, like if you undertake something that's like, I don't know, is there a high probability of death from a space shuttle? I guess you would have to. That's a good question, CH. I guess you'd have to argue how risky it is. I could see her arguing it's not really that risky. They do it up, they've done it plenty of times. I wonder if they did litigate over this. It's considered PR disaster for the company, but made sense. Shuttles had poor safety records. I wonder if there was any insurance involved in what was the submarine that went down? Did they go down to the Titanic? Or am I making that up? The one, do you know what I'm talking about? The one that exploded or disappeared. Titanium? Why can't I think of what it's called? The one where this, I think, Ocean's Gate. Yes, Maury, Ocean's Gate. I wonder what insurance was like for that. I think that one's definitely risky, and that did not turn out well. But I do wonder what the insurance was like for that, because there is a point where like insurance, like you become too risky for the insurance company to want to cover, which exactly what you guys were saying. That's why they would drop them. Okay, let's see what my next one is. Okay, now we are going to tighten. That was what it is. Yeah, that's also just like crazy risk. Oh, that's another sad one. I don't know. CH, ain't no way I'd be going in one of those. No, I don't would not be going either. Okay. All right. So proximate cause is when you are liable for reasonably foreseeable. Okay. That harm, well, yeah, harm um was reasonably foreseeable. Um and must, how do I say this? The harm, okay. I don't like the way that my book is wording it, which is why I'm struggling. But must be a type of that results from conduct. Yes. Okay. Um, I don't love how I wrote it out, but the way that these work together is like something can, like we were talking about, something can be like the factual cause and like it can be the cause, but it might not be like the cause, the closest cause. Another example is like when there's like a chain of like what am I like a pile not or like a pile up or like a bunch of fender benders. Um, people are going to argue like whose fault, like if one car's in the middle, like was it that car's fault, was it the car behind them fault, was it the car behind them their fault? um because at some point it's not the fault of like the middle cars, right? But it is. So the first type of causation, the actual cause, is just proving that like if this car hadn't hit me, this damage wouldn't have happened. The proximate cause, the second part of causation, is where you get to put a limit on it, where you get to say, but what about the what about the damage was foreseeable? So, for example, in the pileup, if you're in the middle, you might not be able to sue the person who's like 50 cars behind you because it's not necessarily foreseeable that them hitting the car in front of them would have led to like a pileup. You probably might, I mean, you can get a suit against the person behind you, and then there's other ways to get to the person who caused the accident. Um, but I think the pileup is probably the best example I've heard in law school. Because yes, the person at the beginning of the chain is the one who caused it, but they didn't know that like they were going to necessarily cause like your car 200 feet down the road to be hit as well. This is why I hate causation. My least favorite. Okay, and then what happens when there is an intervening event? Meaning, in the pile up example, let's say like 10 cars pile up, and then someone drops a mattress in the middle of the road, and then 10 more cars pile up. Is it going to be the original person who started the first pile up? Or is it going to be the person who like saw the first person after the mattress? The mattress is the intervening event. So if I remember right, an intervening event is unforeseeable, it breaks the chain of causation. So my example, the mattress falling, I think is kind of unforeseeable. So the person who started that pileup probably wouldn't be responsible for what happened after the mattress fell in the road, if it was because the mattress fell in the road. Um, yeah, if two people crashed because the mattress fell in the road, it wouldn't be the pileup person's fault because wasn't necessarily foreseeable. Okay, and why did I say that? I said that because an intervening cause um if it is unforeseeable, it is a superseding cause and breaks the causation and liability chain. Meaning if the cause is so unforeseeable, it just like changes the entire effects of whatever happened. It is a superseding cause, meaning it breaks the defendant's liability. Yes. Okay. I think that's going to be my last flashcard. Oh, hi for 5 of you being here. Thanks for listening. Oh, hi, CH. Um, oh, thank goodness you're here. When the 3 requirements are met, the law creates a rebuttable presumption that the defendant's conduct was the primary foreseeable cause of plaintiff's injury. And pile example, if the person at the back is driving way too fast to reasonably stop and add to the pileup. Yeah, exactly. Yeah, yeah. I mean, I don't think law is easy. You just I mean, anyone can do law school. You just have to be willing to like do the time because like I mean, you guys are explaining it just as well as I do, if not better. Um, you just have to be one willing to like be curious, and want to read and listen a lot. In the pile example, if the person in the back is driving way too fast for the conditions to reasonably stop and add to the pile up. Yeah, exactly. Um, then you would have to prove exactly that that person, their speeding would have been like reasonable, to see that they would have made like the pile up worse. Um, exactly. Maurice, already, I'm like, no, Maurice, someone hit you on the head. This makes sense. Someone hit me on the head once, but only because the person in front, oh, head on, not your head. Okay, I'm glad your head is okay. That is a good sign that it is getting kind of late. Someone hit you head on. I'm sorry you were hit head on. That sounds very scary. Someone hit you head on, but only because the person in front of me clipped them by crossing the median. Yeah, exactly. And that would be like a really those are the types of things that people like fight over a lot. Um, Thank you guys so much for hanging out with me. I'm sorry that my voice is a little scratchy. I'm going to get some rest. I'll probably be back tomorrow because I'm trying to get through these torts flashcards so I can start um doing torts questions. And then um yeah, I'm not after my torts flashcards, I'm not sure what the flashcards are going to be what I'm doing next time anyway. But thank you guys so much for joining and hanging out. I will see you the next time I live, which is probably going to be tomorrow. I hope you guys have a good night. Thanks for hanging out again. Bye.